Good morning. Please be seated. This is the time set for oral argument in SAMPSON v. Surgery Center of Peoria et al. CV 18-0113. Out of respect for counsel in the court, I ask that those in attendance please make sure your cell phones are turned off or at least on silent mode. Each side is allocated 20 minutes for argument. Appellant, you may reserve a portion of that time for rebuttal if you wish to do so. However, you will need to keep track of time using the podium clock. We don't keep track of time for you. Counsel, we've read the briefs. We conferenced this case this morning, and we encourage you to keep that in mind when presenting your oral arguments. Proceedings are being recorded and will be posted to YouTube, so make sure your hair is all straight. Before you begin your argument, please state your name and the party you represent so that people watching on the internet can tell who you represent. With that, counsel for appellant, you may proceed.
Thank you, Your Honor. I'm Arthur Lloyd, and I represent SAMPSON, who is present. I understand that you've read the briefs and the supporting documentation, and you're prepared to argue the substantive issues before you today. I believe a brief recitation of the procedural history would be helpful to you in making that substantive decision. This case is about a 4-year-old boy who was diagnosed with obstructive sleep apnea, and for that reason, one of the reasons he went to the surgery center to have his tonsils removed. 2 hours after he was sent home by the discharge nurse, he was dead. The discharge nurse sent him home barely an hour after he came out of the operating room, and the evidence shows that the nurse did not follow the proper procedures and protocols of the surgery center in assessing the boy's condition and in following their own rules to make sure that he met the criteria for proper discharge. And after the child's death, the same nurse went back and altered her chart to reflect that the child's condition was in a better condition than it really was. This lawsuit has been pending for more than 5 years. 4 years ago, the motions for summary judgment, based solely on the issue of causation, were filed by both defendants. By April of 2015, the motions had been fully briefed. But unfortunately, the trial judge, our first trial judge at that time, took a leave of absence for health reasons, and it was many months later before a new trial judge was assigned to the case. Before that trial judge had an opportunity to even set a hearing, the plaintiff filed her supplemental affidavit by her expert, Dr. Greenberg, one of the plaintiff's experts. And in that supplemental affidavit, he gave more details as to his opinions, and he clarified his opinions that had been based upon his, clarified what he had written in his preliminary affidavit. So that's what the supplemental affidavit was. Immediately, both defendants filed motions to strike, claiming that the affidavit was untimely and that it was a sham. 2 months later, the new trial judge, the second trial judge in this case, held a hearing on that motions to strike. The judge did not find, and this is important, did not find that the affidavit was a sham, but he didn't believe that the rules allowed for filing supplemental affidavits, and he struck it. The following month, we had oral arguments on the substantive motions for summary judgment. And at the same time, we had oral arguments on our motion to compel the disclosure of the discharge nurse's employment file, which had been kept from us for more than 2 years. The trial judge ordered the disclosure of the employment file and took the motion for summary judgment under advisement. In our opinion, based on what we could see with the trial court, we felt the judge was going to deny the motions for summary judgment. But 2 hours later, the judge contacted counsel and said, "I've just discovered that one of my friends is part owner of the surgery center. And although the judge said he did not believe he had a conflict of interest, he offered to recuse himself if any of the parties asked that he do so." The surgery center asked the judge to recuse himself, and he did. So now we go many more months, and the third trial judge is now appointed to the case. And after he was appointed to the case, and this is where I think the procedural history is important. After he was appointed to the case, the surgery center filed a motion with the court asking to have new oral arguments on the motions for summary judgment. And the plaintiffs asked the court, filed a motion, asked the court that could the motions be rebriefed. And the judge granted both motions. He said you can rebrief the motions and we'll have new oral arguments. So by the judge granting those motions, their claim that the supplemental affidavit of Dr. Greenberg was untimely, that should be considered as moot because the trial court has the authority to extend deadlines, to extend arguments. So the judge did
But the
that.
trial court didn't extend the deadlines ultimately the trial court, Judge Hagee, didn't allow the supplemental affidavit in.
He said he wouldn't consider it. But on our opinion, the supplemental affidavit should have been considered. We believe the rules allowed for it. But the fact that he ordered new rebriefing and new oral argument, in our opinion, should have negated that. So the only issue, in our opinion, left was it a sham? And neither in the trial court nor in this court have the defendants pointed at any statements or opinions by Dr. Greenberg that directly contradicted anything he had said before. If they had done that, they would have pointed them out in their brief.
Don't they, though? They say, they point to his deposition testimony, I believe, where he says should have been at least an hour or more than an hour, and then in the supplemental affidavit it says 3 hours. Isn't that it?
In his original affidavit, it's 3 hours. The standard of care is 3 hours. That's not directly contradictory. He said that it had to be 3 hours. That's the standard of care. That's from the very beginning. And I've got his preliminary affidavit here, it's minimum of 3 hours to observe, especially a patient with obstructive sleep apnea.
But in his deposition testimony, doesn't he, and correct me if I'm wrong, doesn't he acknowledge that more than 1 hour is standard of care as well?
More than 1 hour is standard of care, and he said it has to be 3. So that's Dr. Greenberg. That was in his affidavit, and it's not directly contradictory to anything that he has said either in his deposition or in his preliminary affidavit or in his final affidavit. So the question before this court is was there sufficient evidence on causation? And the case law is pretty clear that causation is generally considered, like medical malpractice cases, a decision for the jury if we have presented a prima facie case. And as we pointed out in all our briefings, the standard of care required 3 hours. Dr. Greenberg testified to that, as did our other experts. And one of the things before I talk about some of those opinions that were given on causation is I think it's important for the court to note that all of the nurses in the PACU are certified pediatric advanced life support nurses. And they have training on how to revive children that encounter respiratory distress. Plus there's doctors in the facility. So when Dr. Greenberg testifies in his affidavit that appropriate intervention would have been undertaken, I think a reasonable inference should be, well, that would be resuscitation. And Dr. Greenberg used the word resuscitation. This is why we were so confounded in the trial court that the trial judge seemed to think that we had to detail exactly what the nurses would have done to resuscitate the child. And I said to that, suction him out for one thing.
Well, I think in this case there has been a bit of conflation of the concepts of standard of care and causation. And I'll be candid with you, I don't have much difficulty with the plaintiff's causation case. But what I do have difficulty with is Dr. Greenberg's shifting testimony on the standard of care. And so maybe you can help that. I know that at some points, he said that 3 hours was the standard, right? But in his deposition, he seemed to retreat from that. Would you agree?
I don't think that he, and I'm sorry I don't have that in front of me, but I don't believe that he ever retreated from it. I think
Well,
he
I'm
said
looking.
a minimum of an hour.
Let me read to you some deposition testimony. Dr. Greenberg says the standard of care that I'm familiar with is to be observed greater than an hour, right? And then the counsel and Dr. Greenberg get into an argument over whether 61 minutes is enough. But in his deposition, Dr. Greenberg doesn't identify a minimum other than that 1 hour. He says more than an hour, but more than an hour could be any amount of time. Can you help us with that?
Well, we've also got Dr. Xenakis, the EMT, who said clearly the standard of care is 3 hours. And remember, we had Dr. Legally, the EMT was a party at best time. He said it was 3 hours is the standard of care. So that was in there. Dr. Greenberg, in his affidavit, says that 3 hours.
But you noticed only Dr. Greenberg is your expert regarding standard of care and causation, right?
Originally, we had Dr. Greenberg and we had Dr. Xenakis until on the standard of care it's 3 hours, and they were both consistent. They said it was 3 hours. Once we dismissed or settled with Dr. Legally, then we obviously we can't do that because Greenberg is the We've also got our standard of care expert against the surgery center itself, Dr. Hoffman, who's not a medical doctor, but he also says the standard of care. Procedure should have been followed. So frankly, I apologize for not being prepared to defend standard of care because I thought the only issue before the court in the motion for summary judgment was whether or not the plaintiffs had presented causation.
Well, that's why I say there's been a little bit of blurring of the lines between those two and the way this case has been handled.
And I understand. I mean, I've never had a case where it's taken 2.5 years from the time of motion for summary judgment. So yes, lots of and so, as I said, there's multiple occasions where Dr. Greenberg has, I believe, given the appropriate causation opinions that should have precluded granting of summary judgment. And of course, it's this court's duty to make these decisions de novo. And here, Dr. Greenberg says a period of at least 3 hours is necessary for adequate assessment of a pediatric patient like Amari Burks before discharge, particularly with a history of sleep apnea. And then he says, it's my opinion, had the proper level of monitoring been conducted and had a physician evaluated Amari just prior to him being sent home, who would most likely have discovered that the child was not ready for discharge, and that the child's life could have been saved by keeping him longer for observation or admitting him to the hospital. All of the failures by the staff to comply with the guidelines and the monitoring policies of the surgery center and the standard of care for outpatient surgery centers most likely contribute to the premature discharge and the ultimate death. I don't understand why that doesn't meet the criteria of giving a causation opinion, especially when he says appropriate intervention and resuscitation. Resuscitation means exactly what it means for the picture. And apparently the trial court thought we needed to give more on that issue. The other thing I wanted to point out is we felt a little bit blindsided when the trial court started raising the Rule 702 issues, where that was never pled, that was never briefed. We never had any knowledge that the court was going to even bring up the issue of Dr. Greenberg's qualifications until he put it in his order, granting the motions for summary judgment. But both defendants latched onto that as if another reason for this court to sustain that ruling, and we believe that's painfully unfair. They didn't get a chance to even discuss that.
Was there ever an objection to the qualifications under 122602 or 2604?
That issue, as I say, we were completely totally blank.
Doesn't the trial court have an obligation to do some gatekeeping role on expert testimony? In other words, that make sure that the qualifications and the foundation provided for the opinions.
I absolutely agree, but they should.
So you should be aware that that's going to be an issue always.
Absolutely, but they ought to give the parties notice that that's an issue. That was never it was never discussed. They never raised the issue of Dr. Greenberg's qualifications. The trial court, in oral argument, never raised the issues of Dr. Greenberg's qualifications. It came out of the clear blue sky in his ruling. That's the first time anyone was aware that he had any concerns.
Part of the trial court, at least, and I may be misremembering whether it was on reconsideration or at the original ruling, but, and I'd like you to address this, is not only the qualifications, but the foundation for the opinion. In other words, they say that he makes some blanket assertions, but doesn't provide any basis upon which the court can determine that that's a qualified expert opinion. Do you understand the distinction I'm making there?
I do, and in the preliminary affidavit, we set out Dr. Greenberg's qualifications as a pediatric anesthesiologist with multiple years, 30 years of practice, doing thousands and thousands of cases, dealing with children exactly like Amari Burks. Had we known that that was even going to be an issue, we would have trotted out all of his qualifications to give those opinions, because his own training and experience would have
Provided the foundational threshold.
Yes. His own training and experience would give qualifications.
So your position would be that he can establish a standard of care just based upon what he would do based on his training and experience, not what is generally accepted in the community for pediatricians or for these types of surgeries?
Yeah, but both. I mean, the standard of care is a nationwide standard. Most doctors will say that it's a nationwide standard. But
You mean on this issue or in general? Because there are standards of care that are far from nationwide,
Sure.
that are litigated all the time. Some for rural areas, some for areas with more sophistication in the industry. And our law allows the jury to determine which of multiple standards of care apply.
Great, but what I was trying to say is that I believe Dr. Greenberg would say, in his opinion, it's a nationwide standard of care, but also based on his own training and experience in dealing with identical cases over 35 years, he can give the anecdotal evidence necessary to lay the foundation for his personal opinion. So I think it's both ways. If there are no other questions, I'd like to reserve a couple of minutes.
Sure, certainly. Thank you.
But if you have any other questions,
Go ahead.
thank you.
Good morning.
Good morning.
From the very inception of this case, it's been admitted that there is expert testimony required to meet a prima facie case. That includes causation. And plaintiff...
I'm sorry, could you repeat that? I got distracted for a second.
Certainly. I hope it's not my hair.
No.
All right. From the very inception, there's been an admission and certification, in fact, that expert testimony is required to establish a prima facie medical malpractice case. That includes the issue of proximate causation. And from the inception, or not the inception, but when it was time to designate experts, plaintiff, through her counsel, designated Dr. Greenberg as the sole medical causation expert, no one else. And Dr. Greenberg's opinion was that the death of Amari was caused by his metabolization of morphine at a certain rate, together with the fact that he had sleep apnea that caused him to go into respiratory arrest and die. That's his opinion. Now, Dr. Greenberg never, in this entire time, even in his affidavit, which I'll get to, never did he say to a probability that there was something that linked the standard of care criticisms made against defendants to the death. He never did that. And the reason, Your Honors, that the affidavit is such a big deal is because that came 9 months after the response to the summary judgment motion. Now,
At any point, though, I mean, there was a long deposition. It doesn't seem that Dr. Greenberg ever wavered on the idea that the failure to hold Amare for as long as he thought it should was a contributing cause, factual and legal, to the death. And it doesn't take much imagination to draw the lines between the breach of the standard of care, if in fact the standard of care is 3 hours, and what actually happened. I'm puzzled as to why your argument is based on causation and not standard of care.
Judge Swan, if you look at the Barrett case, which is very, very similar in a way, the specific criticism in Barrett was that the physician should not have given an order of low by oxygen. And when he gave that order, the nurse actually somehow created a hyperventilation situation. And that unfortunately blew out the lungs of the infant, and the infant died. So the reason that the standard of care criticism was levied was because of insufficient oxygen to be administered to the infant, not because of this risk of hyperventilation. So plaintiff's theory and the causation theory in Barrett was he fell below the standard of care in issuing the order. Although it was a strange way for it to happen, the infant died as a result of hyperinflation, not underventilation. And therefore we have our causation case. This court held, no, you don't. That is insufficient. You have to link the specific criticism that's being made on standard of care to the actual death. Dr. Greenberg never did that. And, that filing of his affidavit 9 months later is such a blatant admission by plaintiff's counsel that they didn't have enough in the deposition, in the preliminary expert affidavit, in the expert disclosure to overcome the summary judgment motion. Otherwise, they wouldn't have done that. The sole purpose of preparing that affidavit 9 months late was so that they could try to overcome their missing link of the causation issues.
I'm not sure that counsel's intent or evaluation is really dispositive here. The question I would have for you is whether you can paint, let's assume for a moment that 3 hours is the standard of care. How do you argue that there was no causation? Paint the picture that goes any way other than that there was causation.
Absolutely, Ron. The nurses do not stand over the patient. There's no monitoring equipment at all. The child is lying by himself in a hospital bed and periodically checked on by the nurses. And
patients don't have their parents there?
No, not the entire time, not at all. And in co-defendant's brief, they actually cited testimony that talked about that sometimes, even in a home setting, it's better monitored than perhaps in a setting like a surgery center, because this is not an acute care hospital. You don't have cardiac monitoring equipment, you don't have respiration. And so
that might raise a host of other standard of care arguments, mightn't it?
Certainly, but from a causation standpoint, as the court asked me, the child could die anytime not being monitored. It doesn't take long for that to happen. And I think that's what Judge Heggie was ruling on, and I think it's clear from his minute entry that that's the case. That he felt that there was utter speculation, just like in Barrett, just like in Gregg. This court decided Gregg under the same principles. In the Gregg case, there were standard of care criticisms that there should have been policies and procedures adopted. Yet there was no expert to causally link the failure to do so to the death. And this court held without that probability testimony, there is no case. And summary judgment, or it might have been a directed verdict, I can't remember, but the standard is the same, was properly granted.
So why does your position then hinge on whether or not the trial court properly excluded the supplemental affidavit?
No, it does not.
Well, then let's assume, just for argument's sake, that the supplemental affidavit should have been considered by the Superior Court. Doesn't Dr. Greenberg testify or state in the affidavit that with proper monitoring, it would have been caught earlier and likely to have been resuscitated or able to be resuscitated?
He used the words, which are possibility words, could have been saved. That's insufficient. It's been insufficient in numerous of this court's cases.
Well, what would the right word of? You can't insist that he used the word "would have been saved," right? Because that implies a certainty. So what word would you suggest for such an affidavit?
Probability. It has to be a medical probability, and that's clear from the Benkendorf case. This court ruled there that a plaintiff who has the burden of proof in a medical case must establish to a probability. And this is known by all medical malpractice.
Oh, I've tried a few of these myself, but would you agree that there's adequate evidence in the record to support at least a triable question as to whether the standard of care is 3 hours?
On the standard of care, Your Honor, there's differing
Right,
different
but
statements,
that's what
but,
I'm asking. Is there a triable question on whether the standard of care is 3 hours?
This is a good question because, honestly, there's conflicting evidence from one side.
I understand.
Specifically, Dr. Greenberg. So
that's why I'm asking you the question.
I guess since you can impeach your own witness under the rules, technically, then there is sufficient to have a question of fact on the standard of care issue of 3 hours.
Okay, I appreciate the candor.
However, that does not obviate the need to then causally link specifically each of those criticisms, and Dr. Greenberg conceitedly did not do that. When the affidavit was filed, it was filed late. Judge Blomo acted within his discretion to strike that affidavit before the decision was ever made.
Can you respond to their argument that the rules don't necessarily imply a time limit on when you can file a supplemental affidavit?
I'd be happy to, Your Honor. Clearly, Rule 56C states that the response and all supporting material must be filed 30 days after the motion is filed, or such time as the court determines or the parties agree. So it has to be 30 days or an extension of that by agreement or by court order. How do you do the court order? You file a 56, at that time it was 56F, now it's 56D motion. That was never done here. They didn't ask for that relief. They didn't say, let us file an affidavit from our expert. And so Judge Blomo acted within his discretion to say, under Rule 56, you didn't meet the requirements. Now, they said that Rule 56E somehow allows them to file supplemental affidavits at will. That would be completely conflicting with 56C's mandate that the response and all supporting materials, including affidavits, be filed 30 days after the motion is filed. So I think we cited the Decline case on that. You can't interpret a rule, as this court has enunciated, that would make other parts of the rule not make sense. And that's exactly what they're doing. They're trying to say, well, we could do this at any time. That's simply not the case under the rule. In addition to that, I would like to just address the affidavit itself. We talked about what language is required. That affidavit did not, and Judge Heggie was right when he ruled, it did not get them there under Arizona law. Arizona law is Bankenthorpe. Arizona law is Barrett. Arizona law is Gregg. You have to have that probability if you're the plaintiff with the burden of proof. And so your expert has to be able to say it's medically probable that had this standard of care violation not occurred, then the life would have been saved. Why didn't Dr. Greenberg do that? He's a very experienced expert. He's testified numerous times. He knows that he has to do probability, yet in this case he wouldn't. Because he couldn't. He couldn't testify that in fact it was probable that Amari's life would have been saved if he would have been kept the 3 hours, like the standard of care that they were trying to argue applied.
Help me with that, because I'm not a doctor, obviously. Why doesn't it just seem like, from what I can tell, the child asphyxiated either on vomit or due to swelling in his neck? Why couldn't someone have just? It almost seems kind of res ipsa loquitur that if someone had been watching, whether it was a mom or a nurse, they would have been able to give him CPR and he would have been saved. Why isn't that just an easy kind of almost lay conclusion I could reach?
Well, Your Honor, I want to address that if I could.
And that's contrary to like Barrett, where you're talking about inflation of the lungs and how much oxygen is too much, etc. Why isn't this different than that?
Because, Your Honor, first of all, there's no indication that there would have been somebody sitting with him all the time at the surgery center. His mother at home, even though she was instructed to, was not sitting with him at home when this death occurred. And it occurred in the...
Well, that's just an argument that things still might have gone badly if he had been watched. But if the question here isn't between some one method of care or another, it's between care or no care. And that seems to feed into Judge Morse's question about lay conclusions.
Well, Your Honor, in essence, care or no care, in fact, there were issues relating to what was supposed to happen at home. So it's not no care that he would be receiving at home. In addition to that, at the surgery center, with respect to what would have happened, no one said, and this is just not the way it works, that there had to be a nurse standing there the entire time. It just doesn't work that way. There's other patients.
No, but one might reasonably expect that if you are holding a patient before releasing the patient, that the hospital is going to do something to check on the patient. I think it sounds kind of callous to say, well, if we had held him, we wouldn't have watched him anyway. That doesn't seem like normal practice.
And that's not my argument, Your Honor. It's just that the intervals between which the patient would be checked on in no way established that the death wouldn't happen between those intervals.
And your position is that it's the plaintiff's burden to establish medical probability that Dr. Greenberg needed to say something along the lines of standard of care would have been not only that he's kept there, but that he was observed every 15 minutes. And if he had been observed every 15 minutes, then that 15 minutes would have been sufficient to stop him from choking out.
That's absolutely correct, Your Honor. And in fact, that was one of the criticisms that they made against the surgery center, was that they said that the 15 minutes was not followed as closely as it should have been, the intervals for checking. So all Dr. Greenberg had to do was to say, had it been to a reasonable degree of medical probability, the death would not have occurred. And I do need to allow my co-defendant to argue.
I should have asked you ahead of time how you were dividing. So
thank you.
I'd like to address that specific issue that you were asking about, Judge Morse, and also Judge Swan. Circle back to why this is not a lay witness appropriate case. Mr. Lloyd used the word resuscitation. He said Dr. Greenberg mentioned the word resuscitation in his affidavit and his deposition, and resuscitation, we use resuscitation. It's not that simple. Mr. Lloyd is argued that Amari died because his throat was obstructed, because it was swollen. He's also claimed that there were secretions. No testimony about how to remove those secretions. No expert affidavit addressing how to resuscitate. We have argument by an attorney, Mr. Lloyd, who handles a lot of medical malpractice cases. He's not a doctor. He doesn't get to testify about what.
Are you suggesting that there's nothing that could have been done?
I'm suggesting it takes a medical doctor to understand what could have been done.
But what could have been done isn't the issue. The issue in this case is that there was nothing done. There was no attempt because the child's been removed from the center. So it might be very interesting to spin out various scenarios where some problem is observed and talk about what could have been done or not could have been done. But we don't even get to that because nothing was done because he wasn't there.
There still has to be a medical causal link between standard of care and causation.
I understand
makes
that.
sense.
That's MedMal 101. I know there has to be a link, but I guess some of the questions you're hearing are hinting that there's a concern that there might actually be a link that is fairly obvious.
I think it's a speculative link. I'd like to give you an example from an actual case that I had against former Chief Justice Tom Slattery just a few years ago. Similar causation element in that case, but it happened in the operating room. Person's throat swelled shut after medication. If Amari really died because his throat was obstructed, resuscitation is not just a simple thing. It needs to be explained to jurors about what could be done, if anything. Perhaps nothing could have been done to save him. That's the reality. In that operating room, there were two surgeons and an anesthesiologist trying to save a man from an obstructed throat. They tried to intubate, they couldn't get a tube down. Most jurors don't even know what intubation is. They tried tracheostomy. It took them 20 minutes. They still couldn't get it done. I represent probably more anesthesiologists than any practicing attorney in Arizona right now. And I've never heard the word jet ventilation until that case. That's where they try and stick a tube down through the throat.
I've known about jet ventilation for 20 years. I don't know what to tell you.
But you're an experienced judge who has also practiced medical malpractice. You're not a layperson, nor am I. The causal element in this case would have required Dr. Greenberg to say, here is what the standard of care is in a surgery center in Arizona, because it is a unique standard of care. He didn't know anything about the observation periods, only testimony about this 15-minute lack of observation comes from Mr. Lloyd. So we don't know what the standard of care is in a surgery center. We don't know what equipment was available.
Well, I think we have a concession here that there's at least a triable issue as to what the standard of care is for retaining a patient before discharge in a surgery center. Right? I mean, there's conflicting testimony on it, and perhaps a dispute of fact, but nonetheless a dispute of fact that could preclude summary judgment on that issue. The next issue is I mean, you take the plaintiffs to task for speculation, but then we engage in a lot of speculation about the idea that it might have been impossible to resuscitate this patient. That's sort of speculation on speculation, because we don't know what would have been observed or anything because he wasn't there.
I totally agree, Robert, and I think that gets to the core of Arizona law. Jurors cannot speculate about a case this medically complex. They need medical guidance from a medical expert.
Let me follow up on a question, and since I'm asking, we'll let you keep going. It's good to be the presiding. Is there two kind of standard of care issues then? Because it sounds like we might have one, and there's been a concession now that the 3 hours is at least a triable issue of fact for the jury. But is there a standard of care issue as to what standard of care level of observation he would have been subject to? Because I don't see any evidence as to linking that beyond the 1 hour that he was discharged to that he would have actually been observed or subject to monitoring or whatever that might have actually been able to stop this tragedy from occurring. Is that kind of a fair secondary subset of it?
No, and here's why. That was never an issue brief. The motion for summary judgment was based upon the standard of care as we knew it, the allegations were Williamsburg used to state their case. Get out there and link the standard of care to injury causation. We challenged injury causation, and the case was briefed and rebriefed and multiple briefs.
Yeah, I'm sorry. Maybe I didn't ask my question clearly, I guess, because what I'm saying is, even if we assume that there is an issue of fact as to he maybe should have been in the kept in the PACU or at least in the center beyond the 1 hour that he was maintained there, isn't there a separate issue? Is what's the standard of care as to whether or not he would have been observed in a manner that would have allowed resuscitation? Because if it's standard of care is he's just kept there and maybe they stop by every hour, it might not have prevented this. But if it's every 10 minutes, maybe it would have been. Do you see the distinction I'm drawing?
I do, but I think you're asking a question that does not stem from what actually occurred in the briefing and what was challenged in the rest of the trial. But it seems to be a brand new issue that we're discussing here today. And I don't think either side would be discussed today because it wasn't the basis of the trial court ruling and it wasn't part of all the briefing. But to answer your question as directly as I can, it would have been plaintiff's burden of proof to say that there was a secondary standard of care and to produce an affidavit to say that this care was.
Maybe that's why the causation standard of care gets so confusing on this. Take 30 seconds if you want to wrap up.
I have nothing to wrap up in sum. I can tell that you have read the briefs very closely. I can tell that you have your finger on the pulse of this case.
I have to say, as a former trial judge who tried a number of these cases, I've heard the argument that observation isn't really terribly efficacious a number of times. Right? And I've seen it succeed in front of a jury. I can't think of a case off the top of my head where summary judgment was granted on the notion that observation doesn't really matter. Can you?
I think this is the only case that I have had, Your Honor, where that specific issue was the issue. So I don't have the background that you have.
Well, I'm not asking you to match experience. I'm just asking you if you have an appellate decision that you can cite that deals with causation in the observation context.
I cannot think of one, but off the top of my head, I think the counsel is right. When you look at what Arizona law requires, there's a distinction between those cases that are so simple that a layperson could understand versus an expert. You can't let jurors speculate without guidance unless it's really simple case. If Judge Swan, you believe that observation equates this to one of those really simple cases, I think he takes it outside of banking. Our argument is that it's not that simple.
Understood. Okay. Thank you.
Your Honor, if I could, the Bright case actually talks about that.
Okay.
Lack of observation on EKGs.
Thank you, counsel. Counsel for the appellant, you've reserved about 3 minutes left.
Time, I'll be short. I think a couple things need to be pointed out. First of all, in the surgery center, each patient is assigned one nurse. That nurse has no other patients. This nurse was assigned to Marburg's and no one else. So you got monitored. And the other thing that needs to be pointed out, as Dr. Greenberg put in his affidavit, which is also part of the surgery center's policy, and that is that the patient has to be assessed every 15 minutes. And it's not just a look at. They have to document. This is part of the documentation that the nurse that discharged the child went back and altered. She has to document every 15 minutes what the patient's doing, including his breathing, his blood pressure, that type of stuff. And I think the key is what Dr. Greenberg said, talking about the monitoring. That surveillance should have taken the form of personal monitoring by the PACU nurse, which would have required that she follow the surgery center's guidelines and accurately document the child's vital signs, which she did not.
Okay, and on the issue of causation, does Dr. Greenberg ever get there?
Yes, it would have been it said, in my opinion, that had the proper level of monitoring been conducted, and had a physician evaluated Amari just prior to being sent home, it would most likely, I think that means probably, then discovered that the child was not ready for discharge.
You're reading from the affidavit.
I'm reading from his affidavit.
But during his, I'm sorry, go ahead.
How about his deposition?
Well, in his deposition, they never, as we pointed out, they never asked him the actual causation steps. They just asked him, are these your opinions? Yes. This is your opinion? Yes. This is your opinion? Yes. But in his original affidavit...
I thought he said in his deposition, though, that even if a doctor had observed Omari, there wouldn't have been any clues that would have told him that the kid was in trouble.
I remember that one specifically, and the way the question was, if the medical record is accurate, would the doctor have been alerted to anything? And of course, and I think Dr. Greenberg said, yeah, if the medical record is accurate. Whether the record is accurate is highly in dispute because it was altered. And the mother's testimony highly disputes what the nurse's assessment was. So those are questions of fact for a jury. And as I said before, we're here because of causation, not standard of care. That was the only issue that they raised. And so I know I've got 25 seconds left. This child died needlessly. Mom has the right to have her day in court and have the jury hear what happened. We'd ask the court to remand this for trial.
Thank you. Thank you for your briefs and presentations here today. We will take this matter under advisement and issue a written ruling in due course. We will now be at recess to allow the next case to be set up for their oral argument.